Good afternoon, Section Z. Hope you're doing well. Now it's time for a lecture on title insurance. We have a section at the end of Chapter 8 on title insurance that has a couple of cases, but just as a preliminary matter, one question that is asked at the outset is, who is protected by a title insurance policy? And the answer is that the insured party is the only one protected by the policy. Title insurance does not create something like a warranty that runs with the land to successors. So the mere fact that some predecessor had title insurance doesn't allow me to sue on that policy. That policy only protected the party that purchased it. The other question at the outset of the chapter is, what kinds of liability or risks are title insurance policies designed to deal with? And basically the answer that the authors give on page 460 is it's to deal with defects in the public records unless there's a specific exception in the coverage of the policy that would exclude a particular risk. And so let's take a look at one case that they have given us. Here is Walter Rogie Inc. versus Chelsea Title and Guarantee Company. And the problem here is that somebody has purchased property and found out after the purchase that they got a lot less property than they thought they were buying. That there were indications that there's a survey that was erroneous, apparently, that said that they were getting 18.33 acres. The contract said they were getting more or less 19 acres. But later on, when they have land surveyed, they find out that it was really only 12.43 acres. So they got maybe 2/3 of the land that they thought they were purchasing when they bought it. And so they sued the title insurance company. And the plaintiff thinks that Chelsea, the title insurer, should have known about this discrepancy in the amount of land, in part because Chelsea had issued an earlier title insurance policy or policies on this particular piece of land. And their files included a prior deed that indicated that the land was 12.486 acres. And so they had some documentation in their files suggesting that the land was smaller than the current transaction made it appear. Now, nothing in the title insurance policy, though, described the size of the parcel or purported to insure against that. And so the New Jersey Supreme Court decides that in the absence of a recital of acreage, a title company does not insure the quantity of land. There's also an exclusion in the policy that's significant here that says that it doesn't insure against matters which could be disclosed by an accurate survey. And here that would have been, this particular defect would have been disclosed by a survey. So you can't sue on the title insurance policy itself, but the plaintiff has another possible claim against Chelsea that the court decides could have merit. And so here the question is whether Chelsea actually did more than just issue title insurance. Did they play some other role that might trigger liability in this transaction? And it seems that the court suggests that if a title insurance company also agrees to do a title search, then it may expose itself to liability if that search is done negligently. And so here the court remands the case. They note that Chelsea played a little bit different role than title insurers in other cases. They had insured this policy before. They had documentation indicating that land was smaller than the documents for this transaction suggested. There was a Chelsea employee involved in supervising the closing who helped to calculate the purchase price on the basis of 18 acres rather than 12 acres. And so the case is remanded to see whether Chelsea assumed some other duty beyond the title insurance policy that might be the basis for liability. Now, note 2 after the case, down on page 466. Here the authors are getting into the relative protection offered by title insurance versus the warranties in a general warranty deed. Is there an advantage of one form of protection over the other form of protection? And actually, the authors cite this Curtis article suggesting that there are actually pluses and minuses for either form of protection. And so one of them we've already mentioned, title insurance policies do not run to assignees. They only protect the initial insured who paid the policy premium. But if you're talking about a warranty deed, the future warranties and maybe even sometimes the present warranties or covenants will run to assignees. Covenants also may be broader in that they will insure against all defects in the title, and they're not subject to the exceptions that you typically find in a standard title insurance policy. On the other hand, there are some advantages that title insurance has over a general warranty deed. First of all, the insurance company is usually a big company with reserves and is probably more solvent than the average grantor who might make warranties in a general warranty deed. And also the title insurance company may assume a broader liability for defending claims that are asserted. And so they may have to defend against any attack on the title resulting from a defect that's insured, or pay the cost of removing the cloud on the title. If you're talking about a general warranty deed, the promise is only to defend against attacks by the owner of a paramount claim. Now, note 3 after the case, they take us back to the case of Brown versus Lober that we discussed earlier, where the purchasers thought they were buying all interest in a piece of land and later found out that they had only purchased a third of the mineral rights. Let's assume that they had taken out a title insurance policy. Would the title insurance policy give rise to liability? And the authors think that in that case, the deeds in the record chain of title would show the defect and show that, so the title insurance company would likely be liable in Brown versus Lober. The next case that they give us on title insurance is Lick Mill Creek Apartments versus Chicago Title Insurance Company. And here, the plaintiffs are trying to recover on a title insurance policy because they bought property that was contaminated by hazardous waste. And they claim that they are entitled to recover on the policy because the insurers ensured that the title was marketable and that hazardous waste on the property made the property unmarketable. And so the court has to evaluate that argument and concludes that actually there's a difference between the marketability of title, which is what the insurance policy deals with, and the marketability of the land itself, which is what would be affected by the existence of hazardous waste. The policies in question also insured the plaintiffs against liens or encumbrances on the title. And so could that be a basis for liability? Well, the court notes that when you have hazardous waste on the property, you may be liable for the cleanup costs. The government may be able to impose a lien to cover those cleanup costs. But when there hasn't yet been a lien imposed, then there's not yet an encumbrance within the meaning of the title insurance policy. So fairly short. I didn't want you to dwell on title insurance to a great extent, but one of my predecessors as a property professor said mostly what he told his class about title insurance is make sure you get it, and be careful to see what the exclusions are that you are signing up for. But anyway, that's enough about title insurance. We'll move on to nuisance law in our next lecture.